Your Honor. This case concerns certain contracts for a real estate transaction in Sevier County, Tennessee, where the plaintiff was the buyer and intended to purchase a mobile home park from the defendant's sellers. We're appealing the decision of the trial court that found that the contracts were unenforceable based upon some contradictions in the actual instruments themselves. And we contend that any ambiguities in that contract was either based upon a term that was never incorporated into the contract, or it was cured by a subsequent amendment providing for seller financing terms. And so in August of 2018, my client, Mr. Anderson, first contacted the Musicks and inquired if they would be willing to sell this property to them. They responded that they would be interested, but the property was subject to a pre-existing lease with a right of first refusal by a lessee who we've called Mo and who is referred to as Mo in the transcript. In about October, the sellers contacted my client and informed him that Mo declined to exercise his right of first refusal, and the parties ultimately met and executed a contract that was entered before the trial court as Exhibits 6 and 7. So there were two versions of this contract with handwritten notations that varied slightly, but ultimately did not affect the decision of the trial court as to any ambiguity. The trial court did find, however, that a notation beneath the signature blocks that provided a payment schedule and seller financing details to be attached to this purchase and sale agreement was dispositive as to whether or not this was an enforceable contract. The court found that this contradicted the express terms in the rest of the contract that provided for a straightforward cash sale.
Counsel, what was the final agreement here? Is this supposed to be a seller finance transaction, or is this supposed to be a cash sale at the time of purchase? What was the you're saying there's an end agreement that they're meeting in the mines, they arrive there. What was the final agreement?
And so at the trial, our client did testify that he believed that he had a contract to buy this property for $3 million and that it wasn't entirely relevant how the money came.
Well, let's assume it is relevant. What did they agree to, or did they not agree? I mean, maybe we shouldn't make that assumption. Did they not agree in terms of whether they were going to pay $3 million at closing or whether it was going to be a seller finance transaction?
I think that question could be answered best by the testimony of the defendants. When questioned about this notation beneath their signature blocks, by question from Mr. Owens, the parties testified as followed. And of course, there's a notation at the end of the contract about seller financing terms. Did you see that? Look under the signature line, payment schedule. Do you see that? And the appellee testified that has been added. And another question, you were saying that it was not on it when you signed it? Absolutely not, absolutely not. And that is transcript of evidence, page 112, lines 17 through 24.
All right, so let's say we read that provision out. Let's say we accept, what do we do about the amendment? I mean, doesn't the amendment have seller financing language in it? And so did they, my understanding is you're saying the amendment was signed and agreed to. So is that what's controlling in terms of whether they were doing seller financing or whether they're doing $3 million cash purchase?
And I think yes, I do believe that amendment is what controlled the outcome because the parties all signed this amendment. It's not disputed that they did. And so the trial court did hear testimony that the Musicks never intended for that to be a valid amendment. However, that at best creates some sort of ambiguity as to what the parties intended by this amendment. And in that case, I think that I have a case on this. The best evidence of the intention of the parties is to look at their course of conduct following the execution of a contract. And this is Pinson & Associates Insurance Agency versus Creel. And in that case, the court said, the course of conduct is the strongest evidence of the party's original intent. And so what we have here is post-contract, the appellees say, well, we didn't intend to be bound by that. We signed it, but we didn't intend to be bound by it. And so instead of turning to the course of conduct, the trial court effectively ignored it. It didn't.
Well, but in terms of course of, I'm sorry, in terms of course of conduct, don't we also have your client presenting the appellees with multiple new contracts that differ from what you're all claiming is the contract to be enforced? So if we want to look at course of conduct, I don't know that that necessarily helps your position.
The first contract was presented after they signed the original one. So there was a contract, and that was done at the request of the appellees. It wasn't necessarily something that my client was interested in pursuing. They sought the advice of attorney, and they requested that they have a different agreement. And so my client prepared it, but it's undisputed that they never signed it. And so that's not entirely dispositive because they didn't sign that contract. That's not, the course of conduct that I'm looking to is a phone call that was recorded and presented at the trial where the appellees told our client, we want to sell this to you, we have concerns about Mo's right of first refusal, but we're still interested in selling this property to you, we think. And then there was a text message, which was Trial Exhibit 5, wherein Mrs. Musick texted Mr. Anderson and said, can't close in January, can close in February.
Following up on Judge Davis's question, as part of that course of conduct, and clients coming back and presenting new contracts and presenting contracts for options to purchase instead of a purchase contract, and it seems like there's some real uncertainty on your client's behalf about whether there's a binding contract or not in terms of how your client is approaching this circumstance.
Right, and I think the testimony at trial showed that my client did this to try to keep their client happy, to calm any fears that they have so that we wouldn't end up here today. But in any event.
Before you move on to something new, I want to go back to something that Judge Usman brought up, and that is dealing with the method of payment. Do you think that how this $3 million was going to be paid, is that a material issue within the contract, whether it was $3 million cash versus seller financing? Is that material to the formation of the contract?
Yes, I think it is material, Your Honor. I do, and I think that was, remedied by the November 2nd, 2018 amendment, which provided the specific terms of that contract.
Didn't the trial court conclude essentially that amendment wasn't truly intended to be binding here in terms of the parties that testified that the Musick testified that they initialed it as a receipt? Essentially, they put their initials at the top. Did you receive this? Yes, I marked that. There's not a full signature sign on it, or is there? I may be mistaken about that.
There's not a full signature. It is initials, but the position is that that's an error. The trial court's conclusion was an error because there's a presumption that arises in favor of that a party signed and intended to be bound by a contract when they signed it.
But they didn't actually sign it, did they? I mean, there's not a signature on there. There's an initialing of it. There's no. So if we're going to apply that presumption, don't we need to actually have a signature, or do the initials? Are you saying the initials essentially count?
I think that the initials are. I think it's a mark indicating assent is a signature, and that's what these initials are. It's marking the assent to the terms. And so, in the event that their testimony created some ambiguity as to the intent of the parties when they entered into the contract, I do think that their subsequent conduct proves that they did believe that they were bound by this contract. They did say, we can close in February. They obviously believed that they had a contract to sell this park to my client for $3 million.
If we assume that that's a signature, that's part of the contract, that it is back to being a seller finance contract, what are the terms of the seller financing under that amendment? What have they agreed to? And I was looking through it and I had a little bit of confusion in terms of what exactly the terms of the financing would be. What did they agree to in this amendment? I mean, it seems like we've shifted that. If that's then the controlling how this is going to be paid, I think we're back to seller financing. So what are the terms of the seller financing?
And that's Exhibit 10 before the trial court, which is in our brief. It says that there would be $100,000 paid over 7 years for the option to purchase, and then at a 7% interest, which makes it $14,785.71 a year. The purchase price for the 3 acres, or the 30 acres is $1 million. Purchase price for the trailer park is $7 million, which made it or $2 million, which made it a total of $3 million.
Well, how can you have an option to purchase something you've already purchased?
I think that the option was during those payment terms, that he could exercise it it says, once the lease ends, he can, referring to Mo's lease, he would begin paying for the park for the not $2.9 million at 5% interest, 30 years amortization for a 10-year period, at which time the remaining payable is due. So that was the
I have the same
agreement.
confusion as Judge Davis there. If they're supposed to close in February, and this is a 10-year payment structure, and there's an option as part of this, didn't they close in February? And there's no more option, right? I mean, if that's the agreement, they're closing in February, and that's when the purchase, then why are we talking about an option that can be exercised over the course of 10 years payment, or am I misunderstanding that?
I think when they said that they were going to close in February, it was going to be for the execution of the lease option. That for this time, this is obviously an option to purchase at the end of a 10-year period, which the amount payable would be due, and that he would be entitled to exercise his option.
So the amendment took the purchase agreement and made it an option purchase agreement?
Correct. That's what this says. It says that it has an option to purchase.
So it's not the contract, that's not the first contract that we're looking to enforce now that's a purchase agreement. It's an option contract that's through the amendment.
Correct, but only to the extent that those terms vary from the original contract. I think that we provided some case law to the court that says that amendments are valid and only supplement the original contract to the extent that they contradict it. So any of the other provisions that are not contrary to this amendment would still be enforceable.
The original agreement indicates that the purchaser is an LLC. Is that problematic at all? And I understand it lists Anderson as purchaser, but also says that Anderson is a limited liability company, which I'm assuming Anderson is not a limited liability company. Does that matter?
I don't think so. I think he was acting on behalf as an agent of this limited liability company.
Did that actually exist though at the time? Was the limited liability company actually in existence?
That I cannot answer because I don't know.
Okay.
I wouldn't want to say whether or not.
Thank you. You have your rebuttal time. Yes, sir.
May it please the court, I'm Ed Owens. I'm here for the defendants, the Appellee's defendants, Dallas and Alice Musick. As I understand it, what the appellant is arguing is that there was an agreement, original agreement, which I think was Exhibit 6, and another copy was Exhibit 7. And before that, there was a letter of intent that said, this is going to be a seller finance transaction. So he prepares this document that's consistent with this, and Mr. Anderson prepared this. Any language in that document was put there by him. So there's this document that everybody signed, and there was disagreement about what they thought the respective parties thought the intent was. But below the signature lines, there's this statement that says seller financing terms are going to be affixed. I mean, that contradicts what it says. As Cash says, seller financing is going to be affixed. They're arguing that because Mr. Anderson put that language in there below the signature block, you should disregard it. And they've cited a couple of cases involving deeds, and they say, well, because that's the rule with deeds, you put something into a deed after the acknowledgement, it doesn't count. That ought to be the rule with all contracts, which doesn't make any sense to me anyway, because, deeds are contracts, but not all contracts are deeds. And if you look at those cases that they've cited, one of them, the Gamble case, involved an attachment to a deed which wasn't even the deed to the defendant. It was a deed up the chain of title, and it purported to put restrictive covenants on a piece of property. And the people down the chain were saying, well, we didn't know anything about it. And of course, and so you shouldn't count these restrictions against us because they weren't, well, the attachment didn't refer to the deed, et cetera. The court said, well, yeah, okay, fine, but the real reason we're going to rule in your favor is you knew about the restrictions, and we're going to enforce them. So, whatever language they had in there about where you put certain things in a deed really didn't affect the outcome of that case. And the one case they cited was the Anderson versus Howard case, which is also a deed case where evidently somebody wrote in under the acknowledgement, oh, by the way, the grantors are reserving a life estate in this property, and that didn't even get written down in the book when it was recorded. I mean, it was just, and here we got a situation where Mr. Anderson himself put the language in there, and he says, well, because this kind of thing in a deed, which is just not a deed, could result in fraud, you should ignore the language I put in there. So I just think it's a tenuous argument.
We have the amendment, though, here. So, and the amendment does lay out seller financing related process, time periods, payments. Does that essentially cure any problem in terms of if you've got a reference here, you have a subsequent amendment that comes back and says, here's how we're going to handle the seller financing?
Well, one, Mr. Anderson testified very plainly that the parties never agreed on seller financing terms. Plain as day, he said, and I think I got the cite in the brief, they never agreed on seller financing terms. He testified to that. And certainly, you look at this Exhibit 10 with initials at the top, there was, as the court noted, as the chancellor noted, there was conflicting testimony as to what this was supposed to be. My clients say that he prepared this document and with proposed terms, and I asked them to initial it so that to acknowledge that they received it. And they said, fine, but Mr. Musick made it very clear that these terms are not acceptable. Especially, he's, like some of us, he's getting along in years, and he couldn't take a payout over a long period of time for an option or anything else. Plus, this is an option. It says it's an option. It doesn't say it's an amendment to anything. It doesn't mention, it's totally informal. This is from a man, this is allegedly a contract from a man who goes to lawyers and gets contracts drawn up. He did it twice around the same time, brought in 2 more contracts that said.
Counselor, is it your view that we have a conflict between $3 million due cash at purchase and seller financing here, and we also have a contract in terms of whether we have a purchase agreement or an option to purchase agreement? Is that a fair description of the tension here in terms of places where there's not a meeting of the minds or we have conflict?
I'm saying there's never any meetings of the mind on any terms between these parties. Is what I'm saying, and the documents contradict themselves. And the chancellor was listening to the testimony, and they deny, the Musicks deny that they were intended to be. This was a binding contract to do anything. They put their initials at the top of it because he said, well, I want you to acknowledge it.
There's no denial here, though, that they signed the purchase agreement, right? So the purchase agreement in this case was signed. And so I'm trying to figure out the conflict here. So the conflict post-purchase agreement is, it seems to be, if I'm following it correctly, the purchase agreement says $3 million cash a purchase. There's the notation about seller financing. There's the amendment, which is or is not an amendment, but seems to have an approach to seller financing. So it seems that there's a conflict there in terms of seller financing versus $3 million due at purchase. But there's also, it seems to me, a secondary conflict potentially here between option agreement versus purchase agreement. Is that roughly correct in terms of?
Yeah. There's all kinds of contradictions in the documents, and those are the ones you point out. I think are correct. And I'd point out that the Musicks deny totally emphatically deny that original document that was signed was intended by them to be a contract, because there were so many problems with it, and so many things that weren't mentioned. And it said Arizona law applied and all sorts of other stuff. And they say he came in and told them he had to have something signed that he bought the trailer park from Mr. Tomadani, which he had not, and that he had to have something signed because Mr. Tomadani was going to cut the power off. And Mrs. Musick was really concerned about all those families out there in the trailer park weren't going to have electricity. So, that's their story.
Same question as to opposing counsel with regard to LLC reference in the purchase agreement. The original purchase agreement says that purchaser is, if I'm remembering correctly, says purchaser is an LLC.
Yes.
Does that matter? Is that of any consequence here?
I think it matters. I mean, I don't know that he had an LLC. Of course, it said he was an LLC and he couldn't be an LLC. It matters at least because it's one more thing in these contracts that doesn't make any sense and contradicts, contradicts other things. He's saying I'm buying it, but it says the Tennessee LLC is buying it. So yeah, that's a problem. Now, one other thing I'd point out here, they're arguing that you put something below the signature in a contract, it doesn't count. Well, everything in this Exhibit 10 is below the initials. And if you adopt that argument, then nothing in Exhibit 10 counts at all. Again, he put the language in there that wasn't met. They never agreed on terms of any sort. She mentions this telephone call that occurred at some point after November 2nd. And that telephone call, that recording, which surreptitious recording made by Mr. Anderson, was played in its entirety at trial, and it takes up 22 pages, I think pages 61 through 82 of the transcript. And you can read it. I read it a number of times, and nowhere in there does Mr. Musick say, okay, we've got a deal. He's saying, well, we'd like to sell you this, but we're concerned about Mr. Tomadani's right of first refusal. Whether he was right about that or not, that's what he was saying. And there's nothing in there that constitutes a course of conduct that he said in this phone call, indicating that there was a deal. And if he had said, we have a deal, it's under the statute of frauds, you're going to sell land, you have to have it. The contract has to be in writing, and it has to be signed by the party to be charged. And obviously something someone said on a phone call, or I think even a text message, and all she said was, we can close in February. That's not sufficient to constitute a binding agreement. Now, and they're talking about course of conduct. And I think I pointed this out, and I think the court has mentioned this. On at least two other occasions, Mr. Anderson came to them with contracts. One was a purchase and an option. One was just a purchase. And they never got, some of them didn't get filled out. They never got signed. Nobody ever agreed on any of those terms, but he kept coming back. And, at one point offered Mr. Musick $5,000 to sign a contract. Mr. Musick wouldn't take it because by that time he had found out that certain things appeared to be untrue that Mr. Anderson had said to them about his dealings with Mr. Tomadani, and he said, I don't want anything, I want to deal with you anymore. I was interested, they were talking, obviously they were talking for months, and contract after contract after document after document, but there was no deal. And then of course Mr. Anderson unilaterally sets a closing and sues him for not showing up. But that's basically our position. There never was an agreement on any specific, any clear-cut terms of the sale or option or whatever of this property. And the chancellor rightly found he couldn't figure out if there was a deal, if there was a deal, what the terms were. And of course, if there wasn't a deal, there's nothing to specifically enforce. You know, I mean, they argued, they alleged damages, but they didn't put on any proof of it. So the chancellor rightly held they waived that issue. And I'm going to sit down unless y'all have anything else for me.
I hear none. Thank you. Let me ask you, was that at any point a time that your client offered or attempted to pay, whether a down payment or pay money on this contract to them, and that was refused, or was there ever offer, and how much it was?
Did the court ask if it was refused?
Yeah.
He did offer them at $1,500 as consideration for an amendment to it, but they refused the $5,000, and that amendment was
And
never
this was
signed.
$5,000 for an amendment supposedly to a contract?
Correct.
But what
This
about-
wasn't done before the original contract.
Okay. Okay, that was done before the original contract?
No, it was not done before the original contract.
But what I'm looking for is, what did your client offer as far as the contract price or the amount that's supposed to have been paid on the contract?
I
Was
think
there an
that-
actual offer of a certain amount of money? If so, how much?
The contract called for a $1,000 earnest money deposit, and the contract provided that it was a $3 million purchase for this park.
Okay, so was there ever an offer of $3 million?
Yes, it was contained within the purchase and sale agreement.
I mean, actual cash offered, money offered?
Yes, my client set a closing and intended to close either, and he testified either seller financing or a cash offer. It didn't matter to him. And he intended to close in February to provide that money to them.
Following up on that question, at the closing, was he certain whether he was going to pay $3 million or whether they were proceeding with seller financing? Is there evidence in the record related to how your client approached the closing on that?
I don't think that there is evidence as to what he intended to pay, but he said it didn't matter. If they wanted the $3 million in cash, he would have done that, and if they wanted to do the seller financing, he would have done that too.
I thought there was something in the record, and maybe I'm just misremembering it, but something in the record where at some point he said he could not get traditional bank financing.
I'm not aware of that. If there is, I apologize, but I'm not aware of Mr. Anderson testifying that he could not get traditional bank financing.
So there was no agreement at that point then as to how that money would be paid or how they would be compensated?
And I don't entirely find that to be material. If they had shown up and requested that seller financing, that's what he would have done. And if they had requested cash, he would have done that. They would have gotten paid in full the $3 million that they had agreed to under the first purchase and sale agreement. And on that note, I want to just respond to a few things. It's not disputed that they did sign this original purchase and sale agreement. The defendants have now argued that there was never any contract and there was never any terms that our client was going to purchase this property. There was purchase price, there was the identity of the parties, there was the land that was to be conveyed, and that was all contained within that contract. And what he referenced, that there's no cases construing a deed in the same way as a contract, that, you know, a deed may be a contract, but a contract isn't a deed. They're both subject to the same rules of interpretation, which means that this Anderson case that we cite, wherein they effectively say it would be straining construction beyond all reasonable limits to hold that the cause relied upon as reserving a life estate in the grantor's written below the signatures and certificate of acknowledgement, undated and unsigned, constitute a part of the deed. Such construction would open wide the door to the perpetration of fraud. And here, that cannot on its own, that P&S, the seller financing to be attached later, render this entire contract unenforceable when it does call for a cash sale.
I'll make sure that I'm understanding the relationship between the amendment and the original, the post-intent contract to purchase, the purchase agreement. Your client's position is, and correct me if I'm wrong here, that the amendment controls over any conflict with the purchase agreement and is part of the party's contract.
Correct, but if the court finds that the argument of the appellees is persuasive, then giving them the benefit of their own argument, then we revert back to the original purchase and sale agreement.
But your client's position is that is part of the contract, the amendment.
Correct.
And that's your understanding. Okay.
Correct. And if the court has any other questions for me, I can answer them.
I hear none. Thank you very much.
Thank you.
I want to thank both of the attorneys for your presentation. Your case has now been submitted to this court for resolution. You should receive our opinion and judgment within a reasonable period of time. Again, thank you, and you may be excused.
Your Honor.
Madam Clerk, will you please recess court until tomorrow morning?
All rise. This honorable court stands adjourned until the next term of court. Thank you.
Joe, man, I said I saw y'all got a favorable opinion out of these people a few days ago.
Yeah, that was, I started working on that when I was in law school.
You too, sweetie, and thank you so much for your sweet.